an appeal in the matter of the King on the application of the Ramblers Association and the Secretary of State for Environment, Food and Rural Affairs.
Yes, Dr. Bowes.
May it please the Court, Lords, my lady, I appear with my learned friend Mr Simpson for the appellant, my learned friend Mr Bewley for the Ramblers,
Yes.
first respondent. No appearance from the order-making authority of the Council or the Secretary of State. I should draw to the Court's attention a letter from the Secretary of State, which hopefully has reached the Court.
Seen it?
You've seen it. I don't intend to say anything
No.
more about it.
No. And while we're on this, I can tell you that we have read the judge's judgment,
Grateful.
we've read the order decision, and we've read the skeleton arguments.
Thank you very much, my Lord, for that indication. It enables me to focus straight on the core issues that I want to address.
Yes.
That's why the judge was wrong. You should have, hopefully, just a bit of housekeeping, core bundle supplementary authorities and skeletons from both of us. There's one correction, which is that instead of betterment...
Yeah, we got something else.
My apologies.
Yeah. Which didn't seem to have much to do with the case.
Nothing at all, no. That was a surprise. But the essential point, to be very familiar to the Court, arises out of an order-making authority's decision to make an order. We objected, it went to inquiry, and that order was not confirmed effectively on a single basis, which was that an element of the statutory test wasn't made out, whether there was actual enjoyment for a full period of 20 years.
Yeah.
The Court will have seen that was challenged by way of judicial review, and Mrs Justice Lang allowed that on two grounds. Ground one, essentially, that the decision was irrational, to find that the statutory test had not been made out, and ground two was that, separately, the inspector had been steered in her conclusion about substantial enjoyment for the 20 years by her self-direction about de minimis, and that was an error. And
Yes.
With my Lord's permission, as it happens, the appellant appeals against both grounds.
Yes.
And turning to ground one, my Lord.
So just before you go to ground one,
Yes.
the inspector also found there had been no interruption,
Yes.
and that's not challenged.
No. We have all sorts of thoughts about it, but for the purposes of the judicial review, which we were defending,
Yes.
we weren't challenging that, and we say the inspector was right on the intermission point.
Yes.
Ground one, which is the judge's finding that it wasn't reasonably open to the inspector to find on those facts that there had been actual enjoyment for a period of 20 years. We appeal against that ground, but critical to that finding is what the judge says at paragraph 86 of the judgment, which the Court will have seen,
Yes.
is the judge's holding that the explanation for any non-use will be relevant, in applying the statutory test. And the focus of that and this appeal is on section 31 of the Highways Act, which you have behind tab 3 of the authority bundle. Page 7 of the paginated authority bundle.
Yes.
My Lord, I have 6 points under ground one why I say the judge was wrong with respect to so find, and particularly on her contingent holding, which was that the explanation will be relevant. And I'm going to address my oral submissions around those 6 points. The first of those 6 points is that, in my submission, the judge was wrong to hold that any explanation for intermissions is a mandatory consideration when one is applying the statutory test at section 31. In my submission, there are 2 sub-points why that's wrong. Firstly, if one could look at the section 31, there is emphatic statutory language which is used, the word actual enjoyment, actual before enjoyment, and the word full before period. Emphatic statutory language, and in my respectful submission, that is a pointer away from the use being merely notional or otherwise when one is finding a single period for 20 years. But more than that, my Lord, my second sub-point under this first heading is that there has been subsequent parliamentary activity, subsequent legislative activity under the Commons Act. And I do draw support from this. You have that behind tab 5,
Yes.
section 15 of the Commons Act, very, very familiar to my Lord, I know, dealing with an allied area of the law where one can, in broad terms, acquire rights over land through long user, different type of right in question, village green right, not a prescriptive right of way, but the language of the section in my submission is similar. Behind tab 5, page 20.
That's section 15.
Section 15, Commons Act 2006, which was a replication, a recast of the Commons Registration Act 1965, which used the same language. Section 15, it had 3 relevant subsections on qualifying user 2, 3 and 4, just to look at 2A, because they're all the same. A significant number of the inhabitants of any locality or of any neighbourhood within a locality have indulged as of right in lawful sports and pastimes on the land for a period of at least 20 years. So not the same language, but very similar. And the thrust of it is the same. It is acquiring rights by long user. And a point that's taken against me before we get into the submission I want to make is that, well, this is not the same wording, and it is not prescription. And to rebut that, I do say that what is said by the House of Lords in Sunningwell is a riposte to that, and you have that behind tab 15. You have here Lord Hoffman's, what was a seminal judgment, considering the then Commons Registration Act behind tab 15. And at page 199 of the authority bundle, having analysed, well, starting with Roman law, then looking at the common law, then the Prescription Act 1832, then the Highways Act 1932 and 1980, Lord Hoffman says at page 199, just above the letter E, the words actually enjoyed by the public as of right and without interruption for a full period of 20 years are clearly an echo of the words actually enjoyed by any persons claiming right thereto without interruption for a full period of 20 years under the Prescription Act, and 7th of June 1932 under the Rights of Way Act. And his lordship then says, it therefore seems safe to assume that as of right, in the Act of 1932 was intended to have the same meaning as those words in section 5 of the Act of 1832, and the words claiming right hereto in section 2 of that Act. So in my submission, there is authority for saying that we are dealing with legislation on the same or similar subjects, and the House of Lords drew upon the Rights of Way legislation, and it drew upon the prescription private easement legislation, the 1832 Act, when construing the Commons Act. So I rely on that to say that this is a relevant piece of legislation for the court to look at when deciding on the meaning of section 31 of the Highways Act. So just turn back to tab 5 for a moment. The point I want to make is that unlike the Highways Act, the Commons Act contains a deeming provision, and you have that on page 21. And that is subsection 6, where it is provided that in determining the period of 20 years referred to in subsections 2A, 3A and 4A, there is to be disregarded any period during which access to the land was prohibited to members of the public by reason of any enactment. Now
I'm just going to ask, how does this work? Let us suppose that somebody applies to register a town or village green in 2026. And the starting point is that since 2006, the land has been used for local sports and pastimes. And somebody then says, but in 2010, let's say, there was a restriction, and it lasted for 2 years because of foot and mouth or whatever it was, and so the land couldn't be used. We disregard that period of 3 years, and so the 20 years is reckoned not from 2006, but from 2003. Is that right?
Yes. And if one goes on, you get help, because if subsection 7, it tells us those persons are to be regarded as continuing to so indulge, so they are to be treated as continuing to so indulge during the period of statutory prohibition.
Right.
So I'm not sure I quite accept it goes so far as to say they're reckoned to go back further. They're being treated to so indulge during the period of cessation, if the reason for the cessation is a prohibition.
Is that right?
Then what does disregarded mean in subsection 5, in subsection 6? If you disregard the period when access is prohibited, you're doing that in determining the period of 20 years.
Well,
so it just drops out of the picture.
But then subsection 7, which tells us how that is to be applied in a particular circumstance, tells us that in the circumstances for the purposes of 2B, which just turn back a page, which is a requirement that the people continue to be indulging at the time of the application, so that's dealing with at the end of the period, the operation of subsection 6 is that those persons are to be regarded as continuing so to indulge. So it is a deeming provision, my respectful submission, that during the period of statutory prohibition, the persons are treated as being so to continue to indulge, because that's what the Act said.
Is that right? Because subsection 6 isn't telling you what is actual use during any period. It is telling you how you determine the period. So it has to be 20 years, but you don't treat as part of the 20 years the 2 years of statutory prohibition. So if you're going to get to 20 years, you've got to exclude that and include another 2 years.
But in my submission, that wouldn't be right, because that's not how subsection 7 is saying it operates in circumstances in which you'll have to show that you're continuing to indulge at the point of the application. So if, to take my Lord's point, if you are to disregard that period, well then, if there were a statutory prohibition, under subsection 2b, you would not be treated as continuing to so indulge, and that's not what the statute says. It says the opposite. Subsection 7a.
Just have a look at subsection 11a for a minute. One that I've got is they might be treated as continuing to indulge, but indulge during which period? It can't be the statutory prohibition period because that's been disregarded.
But in which case, if just to take that thesis, my Lord, if that's right, then subsection 7a would not have the effect that it purports to have, which is to treat people as indulging at the point of the application, even though they are not actually indulging.
They're indulging before the prohibition, they're indulging after the prohibition, but I don't think it's telling you that during the period of prohibition, you treat that period of prohibition as counting towards the 20 years. That's the only point.
But no, I don't want to dwell on it too much, but I don't want to accept that proposition, if I may. If I could just respond on this.
Have you entitled to reject it?
If I could just respond on
Free
it.
country? Yeah.
Because if that were right, and an application were made under 15.2a, that they'd had 20 years of user as of right, the requirement to bring an application under 2a is that they continue to do so at the time of the application. And subsection 7 contemplates the circumstance in which they are unable to be actually indulging, at the time of the application because there is a prohibition.
Yeah.
And it tells us expressly that they're to be treated, for the purposes of subsection 6, are to be regarded as continuing so indulge. So, in my respectful submission, it is telling us that the effect of subsection 6 is to treat, during the period of statutory prohibition, the user to continue to so indulge.
For the purposes of 2b, isn't it?
Purposes 2b.
For the purposes of 2a and whether they've got 20 years. Yeah.
Well, even if it were so confined, I don't accept that with respect, my Lord, that it is so confined, but even if it were so confined, here is an example of Parliament, for the purposes, even if it is narrowly confined just to subsection 2b, which I don't accept, but if it is, here is an example of Parliament saying, as a mandatory consideration, you must consider why they are not indulging at the point of the application. And if the reason is they're not indulging because of a statutory prohibition that falls in subsection 6, you are to treat them as if they are indulging.
Yes.
And I think even if it is so narrowly confined, I can still point with respect to that subsection and say, here is an example of when Parliament is directing that there is that deeming.
Yes.
And one doesn't have that, either in the wide terms in which I say subsection 6 operates, or in the narrower terms which my Lord has put to me. You don't have either in the Highways Act.
Yeah. All right. Got that point.
And that's the point.
Right.
And what I draw from that, under my first heading, that the judge was wrong to say this was a mandatory material consideration, is that we don't fall in the territory of mandatory considerations. We fall within the territory of a consideration which could be relevant, but it is in the evaluative judgment of the decision maker whether to treat it as relevant or not. And that distinction will be very familiar to the court, but you have that statement of the law behind tab 30. The distinction between considerations which are mandatory, either which arise expressly or by implication on the statute, or those which are potentially relevant, but it's up to the decision taker. And you have that page 772 of the bundle behind tab 30. My lord can quote it off by heart, but I'm just going to remind the court of the viewings distinction that was approved by Lords Hodge and Sales in Friends of the Earth.
Sorry, where are we looking?
Tab 30,
30.
Friends of the Earth, page 772, paragraph 116.
Yes.
Three types of considerations in modern public law: those which are mandatory, either expressly or by
Yeah, this
implication on
is
the statute.
Creed NZ.
Creed NZ, exactly. And in my submission, we're not in one, not in category one, because it doesn't arise expressly, or in my submission by necessary implication of the statute. We're not in two, that it's always irrelevant. We are in three, which is that it sometimes can be, and that is for the judgment of the decision taker, unless irrational. So I accept there is an outer bound, but it's a different category.
There are two components, two relevant components to section 31. There's got to be actual use as of right for the full period, and it must be without interruption. Is that right so far?
I wouldn't accept they're the only two components, but those...
The only two. Those are two components.
Absolutely not, yes.
And if there is a period of non-use, that might be relevant to actual user as of right, and it might be relevant to interruption. And
yes.
you can't tell whether it goes to actual use or interruption unless you know the explanation for the non-use. So why is it not mandatory to know why the way has not been used for a period within the 20 years?
Because you are entitled to know and inquire into what it is, but whether to treat the explanation once inquired and found as a fact as relevant is for the decision maker. So I accept it this far, that a decision maker, if there were a gap in user, one would need to know the circumstances of that gap. I accept that.
The reason for it.
But whether to treat that explanation once supplied as relevant is a judgment for the decision maker. And I want to show the court.
Just a minute. So if there is a gap
Yes.
in use, it is mandatory to inquire into the reason for the gap. Is
Yes,
that right?
I'd accept that.
But whether the reason is relevant to actual use or interruption is a question for the decision maker.
Agreed. Yes, my lord.
Right.
That's exactly how I put it, and that's my second submission. My first submission is it's not mandatory material consideration in every case. My second submission is the better view, the better way of putting for it, is the explanation for the non-use is capable of being a relevant consideration, but whether to treat it as such is a judgment for the decision maker.
The difficulty I've got with that is that's very public law. You confer a discretion upon a body. They may or they may not do something. But Section 31 isn't that kind of function. It's saying that if you do certain things, there is a public right of way. And the question is, what constitutes actual use? And it's not, as a matter of discretion, I think on balance, I let them get away with this or I wouldn't let them get away with it. It's a question as to whether or not there's actual use within the meaning of the statute. So I don't quite see the difference between reason and mandatory consideration, but the weight to be given is for this individual decision maker, and they may say, yes, it is relevant to look at the circumstances, but she's entitled to give it no weight at all, because that's not the exercise. The exercise is whether it goes to actual use.
My Lord, may I show the court, this may illuminate itself through the Prescription Act cases, how that is then bounded. Because I accept that it is not an unbounded discretion, and I want to show the court what the principles were that guided those authorities. So can I just put a pin in that, my Lord, and address that through those points. So that brings us to my second submission, and in my submission that is consistent with the decisions under the Prescription Act, the way I've put it. But I do just want to make this two short preliminary points, that there does need to be care taken before reading across automatically statements that are made in the Prescription Act context to the public law context. And there are two obvious reasons why that is. One, the content of the right acquired is very different. Obviously, it's a public at large under Section 31. Under the Prescription Act, it is for the benefit of one tenement over another. And secondly, that the public rights of way right is enforceable by the criminal law, not so under private easements. And this will be criminally familiar to my law, but I just wanted to emphasise those 2 points because ultimately the way that these things are expressed in these cases does very much depend on the context in which the issue arose. And just to emphasise that point quickly, you have behind tab 17 Beresford, which is a decision of the House of Lords, and you have at page 241, paragraph 34 of the speech of Lord Scott. And I just would invite the court just to cast its eye over that paragraph.
Sorry, which paragraph?
Beg pardon, it's 34, my lady.
Can we just have a minute to look at the headnote to see what the case is all about?
Yes, this was an application to register land as a village green, so under the Commons Registration Act 1965.
So the argument was an implied license of the authority.
That's right.
32 begins with, was it as of right? But it was used, the question is, was it permissive or not?
Exactly so, Lord, yes.
Yes.
Care needs to be taken, even though they're the same language, when you're lifting one from another. And the other short point to emphasise is behind tab 18.
But
Sorry,
what's
Lord.
that's a general statement. How does it apply in this case? What are we comparing? And you're saying we should be careful when we compare it, or what you say you can't just transfer it? Or is it just a general in the ether, let's be careful?
The words actual enjoyment for a full period of 20 years are the same as the Highways Act 1980, the Rights of Way Act 1932, and the Prescription Act 1832. And submissions, the court is going to receive competing submissions about the meaning of those words, drawing upon cases decided under all of those pieces of legislation.
So, are you submitting that the phrase actual enjoyment needs to be understood differently in the context of the Prescription Act from the Highways Act? Is that the submission?
The principle is the same, but how it plays out in different circumstances may and very likely will be different. So one needs to understand when looking at statements made in overture remarks by judges deciding cases under the Prescription Act 1832, one needs to understand the context in which that arose, which is a claim for a private right, as distinct from a public right, and the reason for drawing the court's attention to para 34 in Beresford is that there is recognition at a high level that that care needs to be taken before applying those cases blindly to the meaning of a public right, like Section 31 of the Highways Act. That is the short point I wanted to make, my lord.
Right.
Thank you. So equipped with that, I want to now take the court to the cases, Carr and Foster, Hollins and Verney, and Lawrence and Fen Tigers, which were the cases which were bore heavily on the trial judge's interpretation of Section 31 and the finding ultimately the inspector acted irrationally. You have Carr and Foster behind tab 6.
Sorry, can I just recap briefly? I think you said you had 6 points.
We're under point 2.
We're still under point 2.
Yes.
Right.
They're not all of equal length. We are under point 2.
Right, so where are we going now?
So we're going to Carr and Foster, which is chronologically the first
Yes.
case to look at. You've got it behind tab 6. 1841 case. This was a claim under the Prescription Act, Section 1, for a right of pasture, the right to put cattle on land belonging to another person. And the notable difference under Section 1, as distinct from Section 2 of the Prescription Act, is the time period is different. So for the acquisition of profits and rights of common, it's 30 years. Under rights of way and other easements, it's 20.
Yeah.
And so just also the other contextual thing to recognise is that this was initially a decision by the York Assizes, which was presided over by the Lord Chief Justice. There was an objection raised in the trial that the 30 years user couldn't have been made out because there was a 2-year gap in which the owner of the dominant tenement had no cattle, so they weren't exercising the putative right. That was overruled. The jury found in favour of the claimant, and the defendants obtained what appears to be a rule to show cause, which is, as my understanding, operated as a suspensory order on the effect of the judgment of the jury pending that hearing. And what one has at page 26 are the short judgments explaining why that rule for show cause was discharged. And it was presided over by the trial judge himself, the Chief Justice, but also Mr. Justice Patterson and Williams. And it's best as I can understand it, this is a judgment sort of concomitant jurisdiction to the High Court, sort of operating like a divisional court.
I think procedurally what happened in those days was you got what was called a rule nisi, which was equivalent to permission to appeal, and then the respondent had to show cause why that rule nisi shouldn't be made absolute.
I see.
I think that was the procedure in those days.
Consistent with my limited understanding of early 19th century Victorian civil procedure. And I had the opportunity, I should say, of discussing it with my learned friend. I think we are both agreed that is the status of this. Look.
Just to understand the facts, you've got to have 30 years actual enjoyment. There are 28 years actual enjoyment. There were 2 years when, because he didn't have any cattle, he didn't take any cattle on the land. And the question was whether he was prevented from claiming the 30 years because he was short of cows for a couple of years.
Exactly so. Well, in fact, it was a tenant who was exercising it. The owner then took possession. They didn't have any cows, so they did not exercise. So that was the issue. My Lord has it absolutely. Page 26 of the short judgments. And what I draw from this are 2 overall propositions. One, that it is a matter for the jury, in our case, the planning inspector, but a matter for the decision taker, whether there's been substantial enjoyment for the relevant period. And 2, that the explanation for any gap may be open to some form of explanation. The gap may be open to some form of explanation. And that is what I draw from this decision under Section 1 of the Prescription Act. And we see that in, first, the leading judgment of Lord Justice, Chief Justice Denman, second sentence on page 26 of his judgment. There must be some interval in the enjoyment of all such rights, and it must be a question for the jury, in each case, whether the right was substantially enjoyed for the requisite period. And then dealing with...
It's a question of fact, not of discretion in the public law sense that we understand it.
It's a question of fact. Well, the evaluative fact is whether it's been substantially enjoyed. And he is saying, in my submission, that obviously in the case of a discontinuance user, there will be times when it's not actually enjoyed, but it's a question for the jury whether it's been substantially enjoyed. And then, and the intermission must be a matter open in every case to explanation. And I emphasise there was open in every case, not that the explanation will always be relevant, but it is open to be explained. And there's a concurring judgment from Mr. Justice Patterson, 2/3 of the way down the page, he says, it is always for the jury to say whether during any intermediate part of the period an actual enjoyment has been had, agreeing. And then he expresses in the last section of his judgment this view. He says it is suggested for the argument for the plaintiff might apply equally if they were assessor for 7 years. I am not prepared to say that it would not. It might be that under the circumstances the party had no occasion to use the right. The question would always be for the jury, so long an intermission would be a strong piece of evidence against the continued right, but it would be for them to determine. And then there's a concurring judgment by Mr. Justice Williams, who agrees. And that's what we get in my submission from Carr. We don't get that it will always be relevant, we get that it is open to be explained. And then we get Hollins, which in my submission is of considerable more assistance. It's a judgment of this Court of Appeal, and this was a claim for trespass, which was defended on the basis that a right had been acquired under the Prescription Act, Section 2. So we're dealing with Section 2, 20 years user. And in that case, the jury found for the defendant that there hadn't been a trespass because of the right that had been acquired 3 times over the 20 years. But that was set aside by a rule for show cause, and then that was appealed. So that's the judgment that comes before Lord Justice Lindley, who delivers the leading judgment. The short conclusion, the short decision on this case, was that the court said, well, that was just too little user, whatever the explanation, to amount to...
What was the user? Looking at the head note, the facts are important, Dr. Bowers. You've got to look at the facts. Looking very briefly at the head note on page 27, it was used every few years to cut wood.
Yes.
So it wasn't every year he went to cut wood.
Which one?
Every few years he went to cut wood.
12-year intervals.
Yeah.
And the short decision on this case, the short rationale, was that was just whatever the explanation, too short, too little user to amount to substantial enjoyment for 20 years.
Yeah.
So that's the ratio of that. But, sorry, my lord.
Where is that in the judgment?
You have that, page 39. Upon this point, therefore, we affirm the decision of the Divisional Court, and this point is set out on the final paragraph, final section of the page of 38. Just too short. You see, my lord, page 38, there's a sentence, without therefore professing to be able to draw a line.
I'm quite averse to taking sentences out of judgments out of context. I'm just reading the whole of it, but I'll go away and read the whole of it.
Of course not. But ultimately, that was the rationale for the decision for dismissing, for allowing the appeal, shall I say. But in coming to that conclusion, there is, in my submission, useful analysis about the concept of substantial enjoyment and actual user. And that starts, in my submission, at page 32. Without wishing to take the paragraph out of context, I do just want to emphasise what's said at page 32 on the last substantive section of that paragraph. The truth is that the question whether any particular case a right-of-way has or has not been actually enjoyed for the full period of 20 years.
Sorry, I'm not.
I'm so sorry.
Where are we?
Page 32.
Oh, I see. Next to the second point.
Yeah, exactly. Sorry, I took that too fast. Sorry.
I just wonder if it's just helpful to slow it down and look at page 28, which tells us what the court was actually doing, especially in your submission that this is a matter of discretion, just as it was a matter of fact for the jury. So if we look at 28, it seems that there were 2 alternative ways of viewing the evidence, and the judge had refused to give a judgment because he didn't know what to do. And one way of viewing the evidence was that he did it periodically every 12 years, and another way was that he'd use it every year. Was that not right?
That's
because
exactly
this seems
right.
to be looking, not as you put it, as discretion, but if there are 2 sets of facts, whether or not one set of facts was capable as a matter of law of amounting to actual use and one matter was not.
Indeed, but as it says at the middle of 28, my lord, but this part of the evidence was very conflicting and unsatisfactory. The learned judge who tried the case reported that if the jury meant to find a verdict for the defendant on this ground, such a verdict ought not be allowed to stand. So the every year alternative hypothesis was rejected. And what one was left with was the once every 12 years.
There was other evidence showing that the timber, so it wasn't every year. We know that then.
Yes, we
There's
do.
no evidence that it was used every year.
Yes,
There was other evidence showing that the wood had been cut every 12 years. Is that it?
that's it. And then page 29, the question thus raised is one of very considerable importance.
So there was a gap between 1853 and 1866.
Yes.
Absolutely. And what the court says, whatever the explanation which was supplied, which in that case was, I had no use to use it, it's too long.
No, there are two gaps, weren't there? 1853 to 1886 and 1868 until the period before
1882.
the commencement of the action,
Yeah.
yes. So there are two big gaps.
Yes. And on those facts, too long.
Yes.
So in a sense, an easy case.
The divisional court said you can't establish it given that evidence. And then there was an appeal, is that right?
That's right, my lord, yes. The jury was with the defendant, overturned by a show cause hearing, and then an appeal.
And so the issue that we're actually dealing with is at 29. The question is one of very fair on the one that the right can only be proved to be actually exercised on what is substantially 3 occasions at intervals of 12 years. So that's the actual question.
Yes, my lord.
Yes. Right.
Okay.
And on that question, the answer was no, whatever the explanation. But why I draw attention to it is there is, in my submission, useful obiter analysis about, well, what about a different case? And that, in my submission, starts at page 32.
So this is over to analysis of a different case. Okay, yeah.
By the Court of Appeal.
Yeah.
And page 32, there's a sentence that starts, the truth is that the question.
Yes.
Truth is the question whether in a particular case has or has not been enjoyed for the pool period left by the Act to be treated as a question of fact to be decided by the jury, unless the court sees that having regard to section 6 of the 1832 Act and other provisions of the statute, there's no evidence on which the jury can properly find such enjoyment. This view of the statute will explain several decisions which are apparently conflicting and which it is necessary to notice. So, same principle, different application. Matter of, well, I would put it discretion, matter of evaluative judgment for the jury.
Yeah.
And then page 32 and 33, Lord Justice Linley draws attention to two of those earlier decided cases, Lewison and Hall, and points out at the top of 34, this is his holding about them, that these two cases, however, seem to establish that if user before the statutory period is proved, and user for all 18 or 19 years next before action is also proved, the mere fact of non-user for some time immediately after the commencement of the statutory period is not necessarily fatal, and this we consider good law if the non-user is capable of explanation consistently with the continued actual enjoyment as of right. And that point, that the explanation is consistent with continued assertion of the putative right, is emphasised again at page 37. And just after citing Flight and Thomas, Lord Justice Lewis says, after the semicolon, Freudian slip, Lord Justice Linley says after...
Wrote 1864, I really just...
It certainly was not so intended, my lord. So just middle of the page, after the semicolon, after citing Flight and Thomas, there's this. So, a cessation of user which excludes an inference of actual enjoyment as of right for the full statutory period will be fatal at whatever point of the period the cessation occurs. And on the other hand, a cessation of user which does not exclude such an inference is not fatal, even though it occurs at the beginning or end of the period. And in my submission, that is, just to come back to the pin I put down when I was answering my Lord Justice Lewis a moment ago, that is the bounds of the evaluative judgment. The evaluative judgment is whether the explanation is consistent with the continued assertion of the right. If it's not, it's fatal. If it is, then it carries on and it's be treated as if notionally they're still using it when they're not.
Yeah.
brings me then, my lord, to right up to date to Lawrence and Fentigers.
Do you say that the inspector considered that question?
In my submission, she did. Should be inferred that she did. And just to
Inferred?
fast forward,
Inferred that she did.
yes, because she sets out in detail the explanation. She sets out what it was, how it affected the land, how it affected the user.
She finds the facts.
Yeah.
But does she ask herself the question, is the explanation consistent with the continued, whatever it is?
Assertion of the putative right
Yeah.
is how I put it, yes.
Does she ask that
Well,
question?
in my submission, that is how one should read her decision.
You will show us then
I will, man.
where she considers that question.
Yes.
Yeah.
And to fast forward, in my submission, it's between 126 and 127 of her decision letter.
Right.
So if I may then fast forward to 21st century and to Lawrence and Fentigers, a different issue altogether, which you have behind tab 21. This was a claim in nuisance arising from noise emissions, which was defended partly on the basis of the fact that the right to cause that nuisance had been acquired by prescription. And that issue reached the Supreme Court, but perhaps I'll just pause for the court to look at the head note. There were lots and lots of issues in the case. Very interesting one about whether
Hold on, just
Sorry,
let
my
us
lord.
read the head note then if you've asked us to read it. I'm halfway down.
I apologise, my lord.
Right, so far on page 345, when you get to the Court of Appeal, it's all about whether the Planning Commission changed the character of the area. The judge below had made a finding about acquiring a right to do motor racing.
When it got to the Supreme Court,
Yeah.
one of the issues, the big issue, was about whether the Planning Commission could authorise a nuisance. One of the ancillary issues was whether the trial judge had been right to find that the right to commit the nuisance had not been made out because of a gap in the noise being emitted. And there is comment,
Yeah, there's a 2-year gap.
2-year gap, and Lord Newberger expresses a view about that, and he says, well, the trial judge was wrong to treat that as fatal. And
Yes.
you've got 140 and 141. Sorry, my lord, 382 is where we get that reference. So 140 and 141 is the, in my submission, relevant parts for this case. And what I draw from that, my lord, is that it's not being said that the explanation will in every case be relevant. What is being said is it's not necessarily fatal, and in the facts of this case, the trial judge was wrong. And in my submission, why Lord Newberger was saying that is because, in his judgment, the gap was not inconsistent with the continued assertion of the right. And he cites Carr and Foster, and both Carr and Lawrence and Fentigers quite an important characteristic, which is that the right is contingent on some other event to be exercised. In Carr and Foster, it's having the cattle to put it on the land. If you don't have any cattle, there's no reason to assert the right. In Lawrence and Fentigers, the right was to commit nuisance, but that only arose out of having the events. So if you didn't have any events, you weren't committing a nuisance. You had no need to commit a nuisance because the land wasn't being used. There was a contingent activity that needed to occur in order for the right to be asserted. And that,
if you go on to page paragraph 142, if you read the whole of it, what he seems to be saying is, so long as there's nuisance over 20 years, and the owner should have known that people were using the land for motorcycle activities periodically, the fact that there were a couple of years when they didn't hold events wouldn't change matters. And what's said is that's exactly the situation here.
well, in my submission, that would be respectfully taken too far, because he doesn't say Hollands and Verney is wrongly decided, where that clear bounding of that evaluative judgment is expressed, which is that it's not any old explanation. There might be all sorts of explanations why the user is stopped.
I find this submission hard to understand or accept. If in Carr, the cattle owner had said, I claim a right to depasture my cattle on this land, and I did so in year 1, and I did so again in year 12, and I did so again in year 20, and the reason I didn't do it in the other years was I didn't have any cattle. That would be a hopeless claim.
See, Hollands, absolutely.
Not because it's the fact that the exercise of the right is contingent on having cattle or holding motor racing events has got really nothing to do with it.
Well, in my respectful submission, it does. Can I just explain why? And in my submission, there are those cases where the gap is just too long, whatever the explanation, to assert the right.
Yeah.
And then there are those cases where it is a little bit more nuanced. The gap is not too long per se, but it depends on the reason why it's not being used. And if the reason is not consistent with the assertion of the right, then in my submission, I'm on good footing in Hollands to say that is fatal, because that's what this court has said.
Look at Carr, change the facts of Carr. We know that for 2 years he didn't have any cattle. Say it was 4 months, he didn't have any cattle because they'd all been executed because of foot and mouth. And it took him 4 months to go down the market and get some replacement cattle. Now we know a bit more. We know he didn't have cattle for 4 months rather than 2 years, and we know why he didn't have cattle, because of foot and mouth. Doesn't sound awfully different from saying people didn't use the land here for 4 months because there was foot and mouth. Looking at it overall for 20 years, they were using it. The only period when they weren't using it was because they were afraid of transmission by foot to hoof, foot and mouth. So it just seems odd. And it's not a question of discretion, it's a question of whether or not on the facts it amounts to.
Well, in my submission, I don't need to show that that was the only answer. I just need to show that the inspector wasn't bound to accept that explanation as being consistent with the assertion of the right, because that's what Mrs. Justice Lang has found. As a matter of law, she was precluded. And in my submission, what arises from these cases is an evaluative judgment for the jury, now the planning inspector, to decide that question.
It's the jury because it's a question of fact.
Yes.
And on this part of it, the inspector is finding facts. And then there's a question of law. But she doesn't have a discretion to say, on the facts, it was all right, it was actual use. On the law, I've applied the right test, but nonetheless, as a matter of discretion, I don't think they should have it.
I'd accept that. I'd accept that. And that's not what she does.
Discretion doesn't really come into it here in the way that you're using discretion.
Well, that's my fault for the way I framed it. If I frame it this way, that it is a matter of fact and degree for the evaluative judgment of the decision maker, and different juries on the same facts could find different things. And what...
So they have to be directed appropriately, and the inspector has to direct herself.
Absolutely. And in my submission, my lady, there's no evidence that this inspector didn't direct herself correctly. I have to deal with ground 2, and that's a separate point. I'm not putting that to one side. But on ground 1, there's no evidence to say that she thought that whatever the gap, if there's a gap, that's enough.
Well, that's why ground 2 logically comes before ground 1. There we are. Because the first question is, did she direct herself correctly?
Yes, exactly.
Yeah.
So this is a bit of a roundabout way of getting to what's the real point in the case, if I may say so.
And that depends on looking at the decision, which we haven't looked at yet.
But answering the first question, what is the thing to which you should be directing yourself? In my submission, it is that there are some gaps which are just too long, whatever the explanation. And number 2, there are those which fall in between, which could be explained. And if they're explained as consistent with the assertion of a putative right, that's okay. People are treated as continuing to so indulge, even though they're not actually. If it's not consistent, with the assertion of a putative right, then that's not okay, it's fatal.
Right.
And to take an example, if members of the public didn't want to use a particular way because another way that they preferred had opened up, clearly that would not be non-user, consistent with continuing to assert a right over the original piece of land. And in that case, in the evaluative discretion of the decision maker, even though it might be a fairly short gap of a few months, that would be fatal. And that's what it turns on, and in my submission, that's what our inspector did. But before that, I want to establish, if I may, the parameters of the decision-taking framework, which is that it's an evaluative judgment on the facts.
Right. So nobody could get rights away during COVID because we were all locked in.
Different, no, my lord, because of course there was a legal prohibition. A legal prohibition on going outside.
Well, why does that make any difference?
Well, because if there had been a legal prohibition, that might well be different to the assertion of a right. Whereas in this case, the legal prohibition that was in play didn't bite on these ways, as the inspector found. And that might be very relevant. So, in my submission, none of those cases, Carr, Hollins and Lawrence, to which the trial judge was were central to her analysis, establish what she says at paragraph 86, which is that the explanation will always be relevant, because there's some cases where it won't be, and those cases are where you're not using it consistent with the assertion of a putative right. So my third submission is that that principle may play out differently in different contexts, and there are three examples I want to show the court as to why that is. The first one is that there are different approaches to gaps with explanations. We've looked at Carr and Foster. I've shown the court that in that case it was expressed that you could have a 7-year gap as long as it was explained. The court's finding was that wasn't as a matter of law wrong, but of course we have an example in de Rothschild, which is a public right-of-way case, a divisional court case, where there was an 8-year break, and the court found that explanation, i.e. that the land was requisitioned, did not justify treating the user as continuing.
Was there an 8-year break into Rothschild? I thought the use stopped before simply stopped.
So
It
1940 to
wasn't a break.
1948.
On the facts of this case, there was a break. There was use before,
Right.
then there was a break, and there was use after. De Rothschild, as I understand it, there wasn't a break. It just stopped. The use just stopped in 1940, and that was it.
Absolutely right, my lord, but this court has decided that that as a matter of principle doesn't make any difference, and I can show the court that in Hollins, page 37. And what Lord Justice Lindley said when he was dealing with when the cessation occurred, when the stop occurred, he says the only difference is that if the non-user occurs at the end of the period, to my lord's point, there can be no subsequent user to explain it.
Yes.
And the inference of actual enjoyment for the full year next before action is more difficult to draw.
Yeah, well, those were the facts in de Rothschild.
But I do need to say this, because he says, but we are not prepared to say as a matter of law, such an inference can in no case be drawn. On the contrary, we think it may be where subsection 6 does not apply. So this court has decided that it doesn't matter as a matter of law whether the gap occurs in the middle, at the beginning or at the end. So in my submission, the point that my learned friend takes against me is not a principled answer to that. It may play out differently factually, and I've shown the quotation, but it's not a principled answer.
But hold on. So this is overture, and what they're saying is, if at the end of the use, at the end of the thing that is preventing the use, you still go back and use it, they say it's going to be harder to show continued use. Is that what they're saying there?
No, because in my submission, it's dealing with exactly the Rothschild situation at the end of the period.
If the non-user occurs at the end of the period,
There's no
there can
subsequent.
be no subsequent user to explain it.
Exactly.
And the inference of actual enjoyment for the full period is more difficult to draw. It's saying over that. It's simply saying if you've got no use afterwards, it's harder, because if you had use afterwards, that would be another factor to put into the mix. But they don't go on to say, because it's overture, it's not relevant, that you can never do it. It'll all be a question of fact, but it is relevant, or it can be relevant, that there's no use at the end.
Absolutely. Not demurring from that at all, but simply that there's not a legal principle distinction between the fact that it occurred at the end. All that's being observed is factually, evidentially, that may be harder to prove.
Because it's a question of fact on the evidence as to whether there's been actual use.
Absolutely.
And if there's been a long period of time and it's never resumed, that might point towards it as a matter of fact
And what,
being actual use.
and what might point against it, as a matter of fact, might be that there is a very good explanation why members of the public aren't using it, as there was in De Rothschild. It was requisitioned between 1940 and 1946, and the user didn't continue. And in that world, a decision maker in their evaluative factual judgment might say, well, it's obvious why the public aren't using it. It's because it's requisitioned.
Except it wasn't requisitioned, it was de-requisitioned before the right-of-way was called into question. The public still didn't use it, but the owner was putting up signs.
Yes. But the court found as fact, of course, that the period between 1940 and 1946, when the de-requisitioning occurred, was non-use, not that it's treated as use because there's a very good explanation for the public not using it. They found that from 1940 to 1948, when it was called into question, there was no use at all. And in my submission, if it is the case that one has to look at the explanation, and if there is an objectively ascertainable explanation for why it's not being used, well, then that doesn't matter. So Rothschild clearly is incorrectly decided. In my submission, it's not. Because all it's doing is applying the law as set out by this court in Hollins, albeit obiter, but in my submission correct, that it's an evaluative factual assessment whether the reason for the non-use is consistent with the assertion of the right.
The first question is it 20 years? If there's been a period of time when there hasn't been use, you've got to understand whether that period of non-use is indicative of there not being actual use over the 20 years period, or whether or not there's something that indicates that there's a set of facts objectively which makes it clear that the landlord wouldn't have thought it no longer a right of way, he would have thought something else. And I need to go back and look at the facts of Rothschild. I haven't looked at it, but it seems that there were two things there. If you look at the whole period of 20 years, there seems to have been some period where there might have been a set of facts which explains the non-use, but there were other periods where the same set of facts did not apply to explain non-use. So if you're trying to work out whether over 20 years as a whole, there wasn't, but that's not the reason you're giving by the sounds of it.
But there was no explanation in De Rothschild by the divisional court. I appreciate it doesn't bind this court. This court may just say it's wrong. But there was no explanation in De Rothschild that the period between 1940 and 46, when it was requisitioned, was in some way to be treated as continuing to being a right being asserted because of that explanation.
Sorry, this is why you have to look at the facts against this. Was there a 2-year period from 46 to 48 when it wasn't being used and
Yes.
there's no requisition?
Correct, my lord.
So if you're looking at 20 years, you've got a period of non-use, not explicable, and a sub-period of use, which might be explicable.
Yes.
And they said, well, we're saying that they had the chance to use it and they didn't use it, and that's a jolly good indication that it's not actually as of right over 20 years. Is that all they're saying in Rothschild or not?
Yes, although, of course, looking at Carr and Foster, 7 years apparently fine and explicable, if there's a good explanation. And, of course, the Supreme Court says in Coventry and Lawrence, well, a 2-year gap, in that case, between 46 derequisition and 48 is not necessarily fatal.
And what you're telling me, it sounds as if the Rothschild is an 8-year period,
Yes.
part of which was consistent with objective facts, part of which were not.
Yes, and at no point does the court say we're going to treat this as a 2-year cessation rather than an 8-year cessation. It's an 8-year cessation. And in my submission, if the law truly was that the simple test you have to ask yourself is whether there's an objective explanation, any explanation which objectively just says why it's not being used, well then the cessation wouldn't have made any difference. And in my submission, it's more nuanced than that. And I premise that on what's said in Hollins, that it depends on whether there's an assertion of a right or not. So that's an example of how, in my submission, it can play out differently. And then there's the difference between actual user and availability to be used. This is the second sub-point under this heading. And the trial judge found that the relevant approach is whether the land is available to be used. And she says that at paragraph 60 of her judgment. And Mrs. Justice Lang drew that from cases decided under the Prescription Act. And in my submission, that's very different to how that point has been treated under the public rights of way scheme. And you have a very recent example of that at tab 31 in a case presided over by the Lord Chief Justice, and as he was then, Mr. Justice Holgate and Mr. Justice Sinai. Tab
Sorry,
31.
Just a minute. Where are we? 31?
Yes, please, my lord.
Can you read page number, please?
Sorry, 789, my lady. And in short terms, this was a criminal case where a prosecution had been brought for aggravated trespass. The defendants were acquitted on the basis that the land over which they were said to be committing aggravated trespass amounted to highway. That was appealed to the divisional court by way of a case stated on the basis that availability for public use was tantamount to public user.
Yeah. Which bits do you want us to look at?
So the case stated is at paragraph 21 at 793. Paragraph 21, was it open to me, that's the district judge, to conclude that the public were able to enjoy free passage over the land which in all respects belonged to news printers, that land had, by virtue of section 31 of the Highways Act, become part of the highway.
Just having read the facts, I know you don't like the facts, looking at the facts very quickly,
Yes, Lord.
in the head note, which is usually quite a good thing to do, it looks as if the argument there was all about the fact that although it would have been physically possible to use the land, nobody had actually done it. That seems to be the facts.
Is it the facts?
Is there a fact that's found in the statement of the case?
Sorry.
Is it paragraph 18? Members of the parish were able to enjoy the land, but there's no finding of actual use of the land. Is that what the case is about?
Yes.
It's also the first sentence of paragraph 38, isn't it?
I'm reminded of paragraph 38, but
Of the judgment.
we're then dealing with.
Right, there's no evidence before the court of actual use there. There's a paved area which somebody, if they thought about it, could have used, but they didn't. Like my front garden, they can do it, but they fortunately haven't done it yet.
The submission, my lord, is at paragraph 29. Mr. Greenhall relied upon the decision that.
Evidence of a mere physical opportunity to cross the paved area, not actual use. Okay, what do you want me to look at?
So the submission, my lord, is at paragraph 29. Mr. Greenhall relied upon, just by the letter C. And that is then dealt with from paragraph 32 onwards. Paragraph 33, Mr. Justice Holgate, with whom the Lord Chief Justice, Mr. Justice Sinai, agreed, said the judge did not appreciate that the presumption regarding the dedication of a highway, whether under section 31 or at common law, can only arise if a way of the land has actually been enjoyed by the public as of right and without interruption for a full period, 20 years, unless the test is satisfied, there's no presumption to be rebutted. And then by the letter H, the principle is that there must be actual open public use, or a landowner cannot be said to have acquiesced in use of which he did not know, or could not be reasonably to have known, and so could not reasonably been expected to resist. And then,
In this case, and these words are all in the context of the absence of any evidence of actual use.
yes,
So
but
do we have to read the words in context?
because the proposition, my lord, that I draw from this is that the trial judge was wrong to say, in our case, that availability of use, at least in the public right-of-way context, is sufficient. In paragraph 60 of the trial judge's judgment, she does. So perhaps we should turn that up. Paragraph 60, the judge cites and says, in my view, that interpretation is correct.
So paragraph 60.
Paragraph 60, page 91 of the core bundle, my lord, tab 8.
Yeah.
I take the word enjoyed to mean, as Sterling said in Smith and Baxter, having the amenity or advantage of using. Paragraph 61, in my view, this interpretation of actual enjoyment is correct. So the judge is taking that from the private easement context and concluding that in the public right-of-way context, that is the approach. And in my submission,
I'm
that's not
sorry,
right.
Dr. Bose, you've got to read the paragraph as a whole. What the judge is saying is, It doesn't have to be in continuous actual use 24 hours a day. That's the point she's making.
Well, in my
She's
submission,
not,
there's
she's
only-
not saying that just because there happens to be a path in the countryside and there's no gate to stop you using it, that is actual use. That's not what she's saying at all. The point in the case you've just shown us was there was no evidence of anybody ever having gone onto the forecourt. And the judge, the district judge, jumped to the conclusion that that amounted to dedication without examining the facts at all. You can't just take this little sentence out of context.
my lord,
And it's the same that in Mr. Justice Hilbury's case, there was evidence of actual use.
all I submit, my lord, is that the proposition has to be that it's not mere availability, it has to be actually
Well,
enjoyed, and that's the.
I agree with you, but that's not what the judge is saying.
Yeah.
He's not saying just because the paths were physically there that they'd been dedicated.
Well, if that point is in dispute, I rely on Instone to suggest that's not the case, but it seems as if it's not. The third point, my lord, is about different approaches to the gap. And here I do want to say the judge made a very clear finding about length of time. Her finding at 65, having cited the authorities under the Prescription Act, the judge says these judgments give considerable support to the claimant's submission. They emphasise the distinction between an interruption and an intermission. No criticism there. Then, the length of the intermissions considered in the judgments are measured in years, not months. And in my respectful submission, that is very different to how it's been approached in the public law context. There are cases, and I want to show the court one, where a month's intermission, several months' intermission, is sufficient to break the continuity of user. And whilst the judge is quite correct to make that observation in the context of the private easement world, that is, as I said at the beginning of this section, dealing with the assertion of one tenement with rights over another. It's very different.
You're talking about betterment and Dorset, that sort of case.
Naylor specifically, because betterment's slightly different. 'cause that was a house.
Those, if I may say so, seem to me to be cases of interruption, not actual use.
Well, betterment is, because that was
in
physical.
In both cases, the relevant members of the public were physically prevented from accessing either the land or part of the land over which they claimed to register as a town or village green. They were interruption cases, and as you quite rightly accept, the judge was correct in the second sentence of paragraph 65 to emphasise the difference between an interruption and an intermission. So to rely on cases about interruption in order to criticise the judge on intermissions doesn't seem to me to be a very worthwhile exercise.
Nor one which I would take up, my lord. But
Right.
in Naylor, that was not the factual finding. The factual finding was that there was physical ability to go into the area of the works. And in fact, as it happened, it was my submission based on betterment that therefore there wasn't a physical ouster, and that therefore meant that it was not an interruption case. So in my submission, I do rely on
Right.
Naylor, and I do want to show the court that.
Before we get there, can I just understand what your criticism of paragraph 65 is?
Yes.
She does say the length of the intermissions consider the judgments are measured in years, not months. She might have saved us all a lot of time. She said generally measured in years, not months. But the key thing in 65 is the cases confirm that actual enjoyment is to be assessed by reference to the relevant time period as a whole.
Yeah.
Both before and after the intermission. And that's a matter of fact for the jury. That's what she's saying. You don't disagree with that, do you?
Not with that proposition, no.
So
I
which
disagree
bit you just which bit you disagree with and why?
I disagree with the third sentence insofar as the judge is suggesting that in order to be a qualifying intermission, if I can put it that way, in public law terms, it has to be measured in years, not months. And that observation, in my submission, has borne on her conclusion that the inspector here has acted rationally. The reason I want to show the court Naylor is that is an intermission case. There wasn't a physical ouster, and it was 3 months.
Was she shown Naylor?
It was, yes,
Yeah, okay.
yes. In the scouts, it was also in the authority.
Right, that's all right.
Naylor, where do we find that?
You find that behind tab 22, page 408, I believe.
So it's chapter 2.
Yes, It is, my lord, yes, sorry, is that not?
No, just have 23, don't worry.
Oh, I'm so sorry, I didn't know why that's happened.
The decision of the deputy judge.
That's it, Mr. Howell. And this was a Village Green case.
Sorry, I haven't found it.
I'm sorry, my lady, 408. Issue was whether the County Council, as registration authority, have been correct in law to accept its inspector's recommendation to reject an application to register land as a village green. And that was challenged by way of judicial review on a number of grounds.
Yeah.
One of them.
At para 67, you are challenging the inspector's conclusion that there had been an interruption,
Yes.
not non-use, an interruption. That
Yes.
was the finding of the inspector.
Yes, but my lord, the term interruption does not appear in the Village Greens Act. That is a term of art, which I accept under section 31 of the Highways Act means physical ouster.
Right.
But in the village green world, the terms are used interchangeably without the same term of art. And you can see that because in this case it was found at 19, paragraph 19, that there wasn't in fact a physical ouster. Members of the public were able, if they wanted to go and wander in where all these seawall works were going on.
Yeah.
And at paragraph 68, that was challenged on several premises.
And the fact here that for 3 months in 1993,
Yes.
there were engineering works occurring on that land, so it couldn't have been used for sports because of the civil engineering work.
There wasn't a physical ouster, yes, my lord.
That's what the point was, okay?
Yes, yes, and at 68 you'll see how that was challenged. Point 1, not a relevant interruption because there has to be a physical ouster, and there wasn't. Point 2, the use made of the land for lawful sports and pastimes need not be continuous throughout the 20-year period, and the 3-month interruption need not defeat the claim. And point 3 was a point about section 15, subsection 6, where the court went this morning. And you'll see how the judge deals with that at paragraph 73 and following. Paragraph 73 is the submission. It doesn't have to be actually continuous. Paragraph 74, the...
No, it's much too quick.
I'm so sorry.
If you're asking us to look at the paragraph, I've really got to have time to read it.
Paragraph 73 is the
There
submission.
should have been a break of the use of the relevant land for 3 months. That was an insufficient.
And 74 is the judge's holding that it's an evaluative judgment for the decision maker whether the relevant 20-year period has been made out or not. Challengeable on Wednesbury grounds.
Right.
And 75 is the...
But your
irrational.
main point here, I think, is that although the judgment talks repeatedly about interruption,
Yes.
there is no such separate concept under the Commons Act.
The term interruption is used to describe what would be under the rights of way context, both interruptions in the true sense, i.e. physical ousters, and intermissions of the nature that's before this court. An interruption in user. And the finding, the holding at 75 was, well, that's not irrational to say out of 20 years, 3 months intermission. Look at betterment, that's 4 months, albeit that was an interruption in the true sense, if I can say the word, because it was fenced off.
Yeah.
So,
Can you just ask them to read paragraph 71?
Well, 71, I was just reading actually, and that's that explains it a bit, doesn't it? The first thing you said was they weren't physically excluded, they weren't prevented from going on, so they could have gone on when the civil engineering work stopped, had a quick pastime activity, and then gone off again. And the judge is saying something different about that.
So, in a sense, a harsh judgment, because whilst they weren't physically excluded, there was a very clear explanation why they weren't using that piece of land, asserting rights over it, and it was for 3 months. So, comparative in the scheme of things, a scheme of 20 years, a short period, but found not as a matter of law wrong, not irrational. And in my submission, that, insofar as it was being suggested, that really to get into the nature of an intermission that's relevant, you need to be in the years, not the months. This is the counterpoint to it, is although of course it doesn't bind this court, in my submission it is consideration by the High Court of an analogous acquisition of public rights. So it is legally possible, in my submission, to have an intermission in the months, which is not capable of explanation consistent with the assertion of a right, which does legitimately entitle the decision maker to say there hasn't been 20 years use. So that's my third submission, and what I draw together are 4 situations that emerge from the case law. First situation are those cases like Hollins, where the breaks are just too long for one to say legitimately there's been substantial enjoyment for the relevant time. That's point 1. Second category of cases are those where there are gaps, but the reason for the gap is consistent with the assertion of a putative right in question, like the cattle in Carr or the nuisance in Lawrence. That's the second type of case. The third type of case is where there are intermissions which are explicable, but the explanation is not consistent with the assertion of a putative right. And I say the Rothschild's one of those cases, but I still say that's a category of case which emerges from the cases. And the fourth case is where there are breaks in user, but there's no explanation supplied why. And the unifying feature in my submission of all of those cases is that the evaluative judgment is wide, in each case, subject to the bounds of rationality, and that the outcome on the same facts may be very different depending on the right which is asserted. Private right, public right, profit or common right, right of way. Now, my lords, I want to move to my fourth submission, which is judged against those principles, the inspector was rationally entitled to treat the supplied explanation as not being relevant in this case.
Your third category.
My third category, yes. And now I do want to show the court the decision letter. That's tab 22, core bundle. The page starts on page 287, but the relevant analysis for us is 303. Page 303, the inspector has a heading, actual enjoyment over a full period of 20 years. Para 104, she records the submissions which were being made to her by the landowner, which were both an intermission submission and an interruption submission. 105, that is in my submission a correct self-direction that she records and implicitly accepts as correct the submission by Roxlena that the public need not prove continuous use as nobody uses the right of way 24/7, 365 days a year. Then we have a series of paragraphs starting with 106 where she finds as facts the explanation for the cessation in user, 106, 107. 108 we just pass over by noting, in my respectful submission, that the relevant legal restriction, the right foot and mouth order, did not apply directly to the order routes because they were not recorded as public rights of way. She continues that analysis up to 110 where she's recording those facts. Then, between para 111 and 115, the inspector deals with the question of interruption. And records what was then an advice note issued by the department, and she records what was said by Mr. Justice Carr. And then she picks up her self-direction again at 116. And at 116 and 117 in my submission, she is setting the parameters of her self-direction. And she says here, which bore heavily on the analysis of the trial judge, the crux of the matter here is whether, as a matter of fact, there was a break in continuity of use which was more than de minimis, so that there had not been actual enjoyment of the claimed routes for the full 20 years. And in my submission, that's right. If the break was truly de minimis, well then that's right. That is not relevant. If it was more than de minimis, well then it needs further thought. And in my submission, that is all that's being said in 116. And at 117, if there were doubt about that, she then goes on to say, for the routes to be actually enjoyed for the purposes of 31.1 requires sufficient use over the required 20-year period. The matter of fact, determined in each case, the motive for using the ways is irrelevant. It's undisputed that a short period of non-use, which is de minimis, i.e. too small to be considered, would not affect the running of time. And in my submission, that's right. It is too small, obviously, doesn't matter. The implication is, well, if it's not de minimis, it needs to be considered. 118 and 121, the inspector is then recording what happened at the order making stage. So be very familiar to the court that initially what happens is the surveying authority needs to decide whether to make an order. They decided to make an order here. If there are objections to that, the decision whether to confirm the order and bring it into effect is transferred to the Secretary of State, who appoints an inspector. And there are different burdens and standards of evidential proof at those stages. And at 121, the inspector records correctly that now we're at the confirmation stage. The question of whether use of the order routes continued during a foot and mouth outbreak warrants closer scrutiny. So if truly the way of reading this is that it was just whether there was a de minimis break or not, and having concluded it wasn't de minimis, that's the end of the story. In my submission, it does beg the question why she then went on to make an analysis, as she says, closer scrutiny, of the circumstances, nature and facts which bore on that break. She records, which will become important in my submission, that the roots...
Wait, which break?
So that what she goes on to find is a 4-month break.
What she appears to be, to me, to be asking herself is, was there a break which was more than de minimis? That's the question. And at 121, she is responding to that question. Was there a break which is more than de minimis? That's why she says only Mr. King maintained he'd continued to use Hayton Wood, and then the other witnesses she records in 122 didn't. And it's that which leads her, as I read it, to conclude that there was indeed a break, and it was more than de minimis, and therefore, at 126, it says a mere cessation of use may not break continuity of actual enjoyment. In my judgment, as a matter of fact and degree, this was not a short break that can be regarded as de minimis. Now, you were going to show us where she asked herself the question, was the reason for the break, i.e. people being responsible in the aftermath of foot and mouth outbreak, was that consistent with the continued assertion of a right both before and after the break? Now, where does she...
In my submission, that emerges from both 126 and 127.
126 and 127.
As my lord quite rightly says, she then comes to a conclusion of 126, prolonged period,
Yeah.
those clearly had deterrent effect. Moreover, from the landowner's perspective, the public use had stopped, and so they could not reasonably know that a continuous right to enjoyment was being asserted that ought to be resisted. And then she says, all things considered, so everything she said before, including that, it leads me to conclude that in the particular circumstances of this case, now just pausing there, my lord, if she truly thought, all I need to ask myself is this de minimis or not, why has she then made that observation and finding? And the inference I invite the court to draw, bearing in mind decision letters are to be construed benevolently and to an informed audience and by an expert decision taker, is that she has directed herself to the reason why there was the break and concluded that it wasn't consistent with the assertion of the public right, because that's what she says in the last sentence of 126. And that is what then informs her judgment at 127, that in the circumstance of this case, it hadn't been actually enjoyed for the full period of 20 years. So that is her finding. And in my respectful submission, that's right. She was entitled to make that finding. And in my submission, it was rational for 4 reasons. It was rational because the paths were capable of practical use. It was not akin to them being covered by floodwater or night time. Secondly, there was no legal prohibition on the use of those ways, as she records at 108. Thirdly, it was actually used by an individual, Mr. King, as she found as fact. And fourthly, the length of intermission was sufficient, in my respectful submission, in other cases, see Naylor, to form the rational judgment that over 20 years, a gap of a few months is in the evaluative decision of a decision maker capable of being rational. And the relevant question for the court in a judicial review is, of course, very, very clear to the court, is not whether the court would have had a different view, but it's whether the inspector's evaluative judgment was right or not.
Yes.
And it's not like, in my submission, having the cattle in car, where this was a case where, albeit it was 2 years out of 30 in that case, it was potentially capable of being explained, and the jury found it was explained by the fact that the fact that was contingent on the right being asserted didn't exist. And it's not like in Lawrence, where, again, the fact upon which the claim was based and being asserted didn't exist. This is a case where the paths were legally available, physically available, and weren't prohibited or either by implication or otherwise. And all in my submission I need to show is that it was a rational evaluative judgment for the inspector to say what she said at 126 and 127, i.e. that I've looked at all the facts, I know it's more than de minimis, I need to look about the circumstances of this, I've looked at the circumstances, and in my view, that is not consistent with the assertion of a putative right of way, because you've stopped using it. Perfectly understandable why. But in my submission, that's not the legal question she had to ask herself. The legal question was whether the reason for the cessation was consistent with the assertion of the putative right. In her judgment, it wasn't. Or at least, it wasn't irrational, what she said. So that's point 4, my lord.
Yeah.
Took the court through that. I took notice of what my lord said at the beginning. He read this carefully. I don't want to skim over it improperly, but those are the core points I want to make about it.
Right.
My 5th point, my lord, is a short one, which is that in any event, even if the inspector should have taken into account the explanation and treated it as relevant, the outcome would highly likely have been the same. And the very short point is this, is that unlike Karen Foster and Lawrence and Fen Tigers, the right that's been acquired is an unlimited public right-of-way for all purposes within the frame of footpath use. Whereas the nature of the quality of the user that went into that was a right that deferred to circumstances akin to foot and mouth. And there's no limitation in the order that says, well, you can only exercise this at certain times. It is unlimited. And so if this point had been pressed upon her, and if I'm wrong that she didn't look at this at 126 and 127, and she should have done, well, then she would have been bound not to confirm the order because it didn't have that limitation.
But I don't understand that, actually. If you're relying on Section 31 of the Senior Courts Act, are you? And there's recent authority on the test. It says you've got to look at the nature of the error and to see if you can tell whether without that error she would have reached the same decision or would highly likely not to be substantially different. But if the error here was she hasn't assessed whether the circumstances giving rise to the non-use were consistent with the continued assertion of the use, then we simply don't know what she would have concluded. It's not predicting what she might have done, it's whether you can tell, even without the error, she would have probably come to the same thing.
I accept that entirely.
Yeah, you can't say that because you don't know, if you lose on this, you don't know, because she hasn't considered what the effect of her thinking about the fact that the circumstances giving rise to the non-use may be consistent with continued assertion of the use.
I accept that's the relevant test, not least because my lord authoritatively in Bradbury has set out what the law is.
So your point is there's a mismatch
There's an asymmetry, as I put it in the
between the use proven
Yes,
and the right claim.
yes.
So, suppose that it is established that for 20 years or more, parents have taken their children to school along a particular path, and they have returned at close of play to bring their children back from school using on that same path. And let us suppose that that establishes 20 years use, and I think you would probably accept it does, doesn't it?
Well, it might do. I mean, to be consistent with my submission, it has to be an evaluative.
So somebody says, well, I now want to register this path as a public right of way. If that application succeeds, then there is a public right of way. And you wouldn't be able to say, well, you can't use it at lunchtime because the only use you've ever proved is at 8:30 a.m. and 4:15 or whatever it is. I mean, that would be a hopeless situation.
Well,
or you got some, I don't know, some particularly religious community which never goes walking on a Sunday.
I see, yes.
But use on 6 days of the week is proven, and they apply to register. You wouldn't be able to say, well, you can't use it on Sunday because you never proved that anybody did.
I accept that. All I would say, my lord, and the short point I want to make is that this order contained no limitations at all. And so if the inspector had found that there were true limitations on when it was being exercised, the user, she couldn't have confirmed this order because there's no limitation on it. But can I just make my final submission under ground one, which is this point, which is that even if every single point I've made is wrong, and the court's against me on everything, the judge went too far in my respectful submission in saying that it was not legally open to the inspector to say that the user for 20 years had not been made out. Judge, of course, hadn't seen the land, she hadn't heard the evidence, and if it is truly the finding of this court that the inspector has not asked herself whether the break is consistent with assertion of a right, then the proper course in my respectful submission is to quash, but to remit it for that evaluative exercise to be undertaken. And in my submission, that the way in which the learned judge has framed it is to say that as a matter of law, it goes beyond the merits, it goes way into the merits to say, well, there was only one legal conclusion. And in my submission, that is too far, having not heard the evidence or seen the signs. 18 parts of play here. This is a very large and complicated application for a definitive map modification order on any level. The proper course would be to find that evaluative exercise hadn't been undertaken and to enable the fact finder and decision taker to perform it.
But she remitted it to the defendant for redetermination.
But on the basis of a judgment that says the only fact you could, as a matter of law, on these facts, you could only find that the 20 years was made out. So on remission, goes back to a decision taker, there's a High Court judgment that says, on these facts, as the judge sets out, the only rational conclusion was to say it was made out over 20 years. And in my respectful submission, that was an observation far too far. 124 of the judge's judgment, page 107. The judge records the findings of fact. 126, she says, in light of those findings, I accept the submission no reasonable landowner would conclude. So she's struck that judgment herself.
And is this one of your grounds of appeal?
Yes, it is, Lord.
Yeah.
Yes, absolutely.
I haven't focused on that. What are the grounds?
They are tab 2, my lord, and it is ground 8. The judge was wrong. It's not reasonably open for the inspector to have found reasonable landowner would have no continuous right to being asserted, which needed to be contested.
Okay.
And my lord, if the court is against me on all of it,
Sorry, I've got,
So sorry.
I've got a bit lost. Did you say ground 8?
ground 8.
It's ground 1, sub-ground 8.
Oh, I see.
Yeah,
Okay. Sorry.
para 8 of ground. Yes, quite right.
Wrong column here. It's there. 6 and 1 to 7.
Yes. And in my submission, that went too far, and
It was conceded by the defendant, by the Secretary of State.
Well, yes, but not by us. So, if even if something's conceded and it's contested, then the court has to still make a finding. And in my submission, if the court's finding is an evaluative exercise wasn't performed that should have been, the correct remedy is to record that fact in the judgment and to say, well, it should be the subject of that finding. It went too far to say, well, on the facts, the only thing you could have found is 20 made out.
The decision maker here is the Secretary of State.
Yes.
Yes.
And the Secretary of State accepts that it's not reasonably open to the inspector to find that a reasonable landowner would not know that a continuous right to enjoyment was being asserted. So that is the Secretary of State's evaluative judgment on the basis of the facts found by the inspector. What's wrong with that? Your clients are not the decision maker, the Secretary of State is, and that's what she said.
But the Secretary of State isn't buying the court. The court, we are contesting the correctness of that legal analysis, as we are entitled to do, Lord, and we are entitled to the court to find that on legal principles, irrespective of what the decision maker thinks, not on the basis of any explanation. Of course, the court has before it grounds from the Secretary of State saying these points are unarguable, then a letter saying we concede one ground, no legal analysis, then we have another letter that says everything Mrs. Justice Lang says is right. And we are entitled, and landowners entitled, to have a judgment from the courts that say why we're wrong. And in my submission,
Can I just
Sorry.
understand, the Secretary of State, the decision is taken in the name of the Secretary of State.
Correct.
When Ms. Sword is appointed, was she appointed to determine the
Yes.
application? So
Yes.
she decided the
Yes.
application. Right. So her decision, assume for the moment that she's wrong and it's set aside. The Secretary of State will then have to, because the Secretary of State is the person responsible for taking the decision, will the Secretary of State have to appoint a new inspector, or could the Secretary of State simply decide it?
strictly speaking, it would be a question of relief, how that would work. In
No,
practice,
forget that. What does the Secretary of State have to do as a matter of law under the legislation? Does it have to have an inspector decide it, or an inquiry where the inspector finds facts, which seems to be found, or could the inspector simply decide it himself? The Secretary of State decides it himself in the light of the judgment.
I want to check, but I understand that there is a transferred jurisdiction for the inspector, and that if it were quashed, then it would go back to the inspectorate to redetermine it in the name of the Secretary of State.
That's quite important, though, isn't it?
My lord, I just to say, we'll check. Normally it goes back to inspectors, but I can't remember. It's in the schedule whether there's a.
Is there a call-in procedure, that sort of a
There's
thing?
not a call-in procedure, but there may or may not be discretion without knowing, without checking. I don't want to say whether there's a residual discretion for the Secretary of State to retain it. So I suspect if we'll check that,
Of course.
hopefully agree it.
So I'll pass over that.
Right.
But in my submission, what's said in a letter to the court without any legal analysis doesn't bind the court, and none of us would be submitting that that's the complete answer to the appeal. So she may be wrong to have made that concession. We say she was.
Right.
And just to make this short point, that if it were otherwise, and the Secretary of State had already said that, and that was to be taken to be their position for all purposes on these facts, well then it would be deeply unfair when it were to be remitted for people objecting to the order, because the decision maker would have already said there's no rational basis on which this decision could be anything but. And if that was truly the intention, which my submission it clearly isn't of what the Secretary of State's correspondence with the court to say there's only one way of potentially determining this at all, which is that the 20 years user is made out
On these facts?
on these facts.
On the facts found by the inspector?
Yeah. But they can't truly mean that whenever it goes back to the inspector or to the Secretary of State or whichever, that I'm bound to make this out.
Well, it depends on whether you're entitled to reopen the facts or not. Let us suppose that the inspector was not making the decision but reporting to the Secretary of State.
Yes.
The Secretary of State would be perfectly entitled to say, on the facts as found by the inspector, it is the conclusion that the right-of-way was not established is irrational. That would be perfectly open to the Secretary of State. Or she doesn't even need to say irrational, she could just say, I disagree with it.
Yeah, made out, yes.
Actually, again, one does actually need to look at everything. If you look at page 107 to 108, 124, the inspector found the following fact. And the fact says she's asked the wrong request. But they set out the facts, and there's no dispute that those are the facts as found. Then she observed, and it's correct, that the restrictions imposed by the right of, by the foot-and-mouth restrictions were temporary. That's not in dispute. And that wouldn't have affected their status, might have affected use.
Public footpaths.
Yeah. 126 is the only bit where she says, where the judge says, I accept the submission made that no reasonable landowner would conclude from the absence of public use in the period of restrictions that the public possession of the right has been withdrawn. So there she's forming a view as to whether or not a landlord, a landowner would have thought this. And then she goes on to say that she agrees with the defendant's concession. So that's what she's actually said. She hasn't actually said that this is 20 years user as of right, although I accept that it's argument from 126 that that's the consequence, because she said that no reasonable landowner would think that the temporary restrictions in these circumstances indicated an abandonment, if you like, of the use. But that's what she's actually decided.
Yes. But in the circumstances of this case, where there was 1 point on those facts and 1 point in the decision, the consequence of those paragraphs is that, in effect, there isn't an alternative lawful outcome but to confirm the order.
Yeah.
And in my submission, if the court's against me on everything I've said, the proper course would be to say, you decide, Secretary of State.
Yes.
The answer is. So, overall on ground one, my lord, I say the judge was wrong to conclude the inspector acted irrationally. The critical error was her finding at paragraph 86 that the explanation will be relevant, as in will as a matter of law be relevant. The inspector understood the explanation is only relevant if it's consistent with the continued assertion of a right, and the circumstance of this case, the inspector came to a rational conclusion. There's my submissions on ground one, my lord. I now turn, if I may, unless there are any other questions from the court on ground one, to ground two. And the focus of this is the inspector's analysis at 104 and following, which I've shown the court. And there are two criticisms which the judge had of the inspector's analysis. First, that the inspector was steered in her assessment by making reference to de minimis. Steered in her assessment by making reference to de minimis, and the judge says that at 118 of her judgment. And in my submission, that's wrong, because the inspector clearly is not steered by simply asking whether it's de minimis or not. She performs a detailed analysis addressed to knowledgeable parties at 104 to 127 about the circumstances, nature and quality of both the break, the 4-month break, and the 20 years as a whole, and makes a finding about 20 years as a whole. And secondly, the judge said that the inspector failed to ask the statutory question whether the ways were actually used by the public, and she says that at 119. And we say, with respect to the trial judge, she was wrong on both of those points. The starting point in my submission for this question is what the judge says and what she found at para 114. Because at 114, the judge didn't accept the submission that was made. She says at 117, after the decision, the inspector summarised the principles applicable to the assessment of actual enjoyment and added that it's undisputed a short period of non-use which de minimis would not affect the running of time. I agree with Dr. Bowes that this summary did not repeat the error at 116. And in my submission, that was an important finding by the trial judge, because what should have flowed from that was a presumption that she did apply the legislation correctly, absent positive indications to the contrary. And asked to read 113 as well, or reread.
Just reading 112 to 114, she's saying she made it clear, the inspector, that de minimis was the test at 113. However, at 114, she's a bit more guarded, and that paragraph read on its own wouldn't show that she'd applied a de minimis test. But that doesn't matter, because she did, because of 116. Or have I misread what she's saying?
Well, in my submission, that is what she has found.
Yeah.
I don't accept that's the correct way of reading those paragraphs. The correct way of reading those paragraphs, in my submission, is that the inspector has made the unremarkable recording that something that's de minimis can be disregarded.
Yeah, no, you've taken us through those paragraphs. Really, it's for us, isn't it, to read the inspector's decision and decide what it was that she was doing.
Yes, but all I do just want to emphasise on the approach, which will be very familiar to the court, is where there has been a correct self-direction, there is a presumption which follows. So says this court in Jones and Mordew, that the decision maker has got the law correct unless there are positive contrary indications. And
Well,
my
I thought
submission,
that, but in looking at the self-direction that the inspector gave herself, you've got to look at the self-direction as a whole.
of course,
Yeah, right.
and
we know that.
what she's saying in 116 and 117, take that as a whole, is
Well,
that
I'm not sure it's right to take section paras 116 and 117 as a whole. You've got to look at 116, 117, 126 and 127.
Yeah. In this case, you've got 105, where she states doesn't have to be continuous over the whole period. That's right. That's the beginning of her analysis. You've got 116, where she makes the observation that something that's de minimis doesn't need to be worried about. That's correct on its own terms. 117, she makes the correct point. She's got to look at actual enjoyment over the 20-year period. And then at the end of her analysis, 127, she says the same. You've got to look at the 20-year period. So in my respectful submission, you've got not only bookended, but in the middle of her analysis, 3 correct statements of the law, which should frame and bear on how one reads her decision. And she hasn't said, in my submission, anything wrong at 116. It's not positively wrong to say that something that is de minimis or not, something that's de minimis can be disregarded. That's true. And the High Court made no criticism of the inspector's observation to that effect in Naylor. And what she, if truly that's what she meant, and the way of, I would invite the court to test this, as I know the court will think about it very carefully, is simply, if she truly thought, all I need to worry about is if it's de minimis or not, why is there paragraph after paragraph of analysis of the nature and quality and the facts surrounding that break? She should have just said, it's de minimis, 4 months, too long, end of the picture. Why has she lengthened an already very lengthy decision letter dealing with that point? But I do accept, my lord, that ultimately it is for the court to read those paragraphs, and there's probably very little I can help the court on getting any further in what they mean.
Yeah.
But you have my submission on them.
Certainly.
And overall, I say we submit that because the inspector's analysis was right at 117 and was bookended at both ends of her analysis by correct statements of the law, the proper inference to draw is that she applied the law correctly. And remarking that a de minimis intermission can be disregarded cannot possibly be said to be a positive contraindication, because that is correct. And it was not a fair, in my submission, finding of the trial judge that the inspector was improperly steered in her analysis by de minimis or otherwise, because that's not the question that she's answering. Well, may I just turn around for a moment to address everything? Well, unless the court has any further questions for me, those are my submissions.
I have one, if I may. Mr. Bewley has set out some propositions in his skeleton argument. Lost for a moment. Yes, page 46 of the core bundle, tab 4. Are there any of those propositions which you dispute?
Yes, my lord, 7
7 you dispute.
will be relevant to consider.
Right.
Do not accept that it is mandatory material in the sense that's meant. Consider in every case the explanation, because there are some cases where the explanation won't be consistent with the assertion of a right. So I don't accept the terms in which it's put there, which the court will note is how Mrs. Justice Lang puts it at para 86. So that's the point there.
But what Mr. B said, it would be relevant to consider any explanation for that omission, so as to consider whether it's consistent with the assertion of a right. That's all right, isn't it? You've got to ask, is what is said consistent with the assertion of the right?
Yeah.
You have to do that, don't you?
I accept, but it's not right to say this point was correctly captured by Lang J, because how Mrs. Justice Lang puts it, in my submission, in considering that question objectively ascertains facts which place the public's contact in context will be relevant to answer the objective question, and in my submission that's not right.
You say may be relevant.
Maybe
Relevant, okay.
relevant, yeah.
But it's not the proposition. You disagree with. It's the summary of what the judge said and agreeing with it. Okay, yeah.
And in proposition 6,
So up to the first sentence of proposition 7, you do not contest. What you do contest is the way the judge put it.
yes,
Is that right?
yes. And point 6, my lord, a related point. So intermission in use is relevant but not fatal is what's said. In my submission, not necessarily fatal is a better way of putting it. there might be cases where the intermission in use is fatal, and you've got Lord Justice Linley and Hollins where he says if it's not consistent with the assertion of public right, then it is fatal.
Where are you criticising or correcting and use the word fatal?
So it's, proposition 6, so intermission in use is relevant but not fatal. Well, in my submission, there are cases where it can be, so it's better to say necessarily fatal.
Right. Clive.
No, that's it. Just
Yes, thank you, Dr. Davis. Simpson, do you wish to add anything? Just before you start, Mr. Bewley, we will just retire for a few minutes and see where we get to.
Yes.
Court rise in favour.
I think the only point. The judge should have found it was irrational. Yeah. And I'm going to say they're not bound because the facts were a bit large, but on the inspector's
Court rise in favour.
Mr. Bewley, what we would like is your joint agreement, if possible, to what powers the Secretary of State has
Yes.
on remission.
Sure.
And that's all we want to know, and we'll give you till 2 o'clock to
Yes.
find out the answer.
That's fine. Well, can I just double check where that leaves me, as it were? I followed the kind of general implications of that, but specifically, that question arose, obviously, in the context of Dr. Bose's submission that the judge had gone too far. So I take it that at least that point might still be at large, as it were, to a degree, or at least unless you tell me otherwise. So it may be, obviously, we can look at that, and I can see it's sensible to do that, come back to you with an answer on that. But do I take it that, I mean, should I be thinking about making submissions on that point apart from the...
I think it would be as well if you did.
Yes, okay, fine.
What troubles me is I don't know what happens next. Does
Yeah.
the
No, I
Secretary
understand why you're-
have to appoint an inspector at
Yeah,
all?
yeah.
Does she have a discretion to appoint an inspector to report?
Yes.
Does she have to find facts even though all the facts are found? It's what happens next.
So I understand, my lord, and if I may say so, I understand why you're asking it, but it's not my own, in response to this argument, it's not my only submission that the point about what the powers are. I have some other points to make, so I just want to, you see what I mean? Yeah. Okay.
Anyway, that's the only
But I
point
understand,
we're
yeah,
interested
I
in.
understand. I'm great.
2 o'clock.
Thank you.
What rise is able?